15th of July 2024, I have come up before this honorable court that an application for alimony pending was allowed by the Lonnet Additional District Judge Court as March without going to the entire set of documents that was filed before that particular Lonnet. I draw your lordship's attention. Your lordship looks at paragraph 4 of my application. First and foremost, I filed the divorce petition in the year 2019, in the month of August. And from the very beginning, I was continuing paying the amount, maintaining my family. I did not stop even after filing the divorce.
There is a child of the marriage?
Yes, ma'am.
Yes.
And immediately, as usual tactics, adopted the opposite party is the law. She is the wife. She filed an application alimony. Your lordship is aware of the provision of law regarding section 36, you can get alimony. She is earning around 60,000 per month. And how much I am spending behind the family?
What is your income, Mr. Bose?
At present income is take home salary is 1,62,000. Out of that, every month I am taking your lordship looks in paragraph 4 of my application along with that documents, supported documents.
What is the amount granted?
50,000 per month.
For the wife and the child?
Wife and that child. 66,000.
You filed your affidavits of assets in the court below, both of you.
66,741.
Mr. Bose, this maintenance of uncle and all these things, in spite of those, you have to maintain your wife and child.
Entire thing, how much I am paying, entire set of paragraph 4.
Whatever you are paying, electricity charge, these are your normal expenses. If she was living with you, you had to pay this amount.
Paying for the child, even after that order, I am continuing to pay.
Whatever you are paying, an amount has been directed to pay. Whatever you have been paying, suppose that merges with the order. What is the amount granted? Let us see in the order. Let us see the order first. What is the child? What is the age of the child?
Age of the child is around 12 years.
She must be studying in some school.
I am paying everything for the education expenses. Every document I have annexed to this application and I have placed before the learned court bill also.
Her net income is 58,501 as per the finding of the court bill itself. And your income 1,62,000. Yes, on the basis of that only.
96 of my application. She has placed such this document before the learned court bill. In addition to other income, which I cannot put up to, from the bank statement can be seen that she has other income also.
Joint income of the parties, what is this? 2,20,000 plus 18,000 rent from jointly owned flat. So both of you are earning that rent.
No, it's completely a vacant flat. It was submitted before the learned trial court. Completely vacant, and I have also submitted to the.
Anyway, we suppose that income is irrelevant because that they have claimed that it's a joint income, so if you cancel out each other's income. So we are not going into that at all. But apart from that, 1,62,000 and she's earning 58,501.
In addition to that, I'm still paying. In addition, 58,068, 66,740.
What is the amount asked for by her, for her client? For her child. Is any breakup given in the application for alimony?
Yes,
what is the amount sought for her child?
At first, it was sought for. It's paragraph 7 of my application. 35,000 and suddenly she increased it, paying for 60,000.
Increased how?
Taken out an application.
Application for what? Additional part amendment. 60,000 for the child. Have you annexed her affidavit of assets in the court below? So show me from there. Page
96.
96. What is the expenditure she shows for a child? 96 is something else. That's her salary.
Yes.
It's 50,501. What do you do, Mr. Bose, your client?
I'm working at Price Hotels because I'm a manager over there, and I have disclosed my income with all the proofs of income and every document.
I want to see the affidavit of the wife regarding her child's expenses.
Right.
He's a son or a daughter? Son. Studying where, Mr. Bose?
In St. James School, 12 years.
And not only that, I have paid for the learned court below. I am ready to pay on the actuals. I provide the weight.
50,000, why 50,000, Mr. Well, you are earning 50,000.
I'll just indicate I have just got a chart.
That you are competent.
Yes, definitely. Sir, this is a chart that I have received from my client. If my lord kindly considers this chart, In terms of the order, it has been directed to pay 50,000. However, in spite of the order, my learned senior friend's client has not been paying that. And
So go whatever are the arrears, you are entitled to recover by execution. We are
my
not.
lord, we have
We are not
execution is
concerned with that.
pending.
Yes, that will take its own course. But regarding the amount of alimony directed, 50,000 is exorbitant.
No,
You
but
are earning
that
50,000 per month.
No, my lord, I'll just indicate. I have further.
For your son, we can consider, but for you,
For
nothing is-
son,
yes.
the total expenses, as I have got instruction, is close to 56,000.
But we get that. You must have disclosed in your affidavit of assets in the
My
court
lord,
below.
that
shows
has
that.
been-
Certain statements like enjoying birthday party, everything.
No,
No,
my lord,
take your
that is
signature
not-
also.
the school's fees are there.
58,000 is sufficient income. You have sufficient income to maintain yourself.
My lord, to
Not
an
just
extent,
because he's earning more does not mean that he'll have
My
to
lord,
pay.
at the
For the
same
son also you have to share because both the parents are earning.
Yes,
So both of you have to share. It will be proportionate to your income. So it
exactly.
will
Now, my
be,
lord,
yes.
my income, admittedly, as I have provided in the chart, is as on date is 60,000 per month. My income,
58,000 something, yes.
58,600. My
1,26,000,
client is 2,09,000.
No, trial court finding is 1,62,000.
But my lord, as per my instruction, it is 2 lakh.
Salary.
That is
You have
the
not
total.
preferred any revision, Mr. Guho. Please come to page 2 of the impugned order.
Yes, ma'am.
Your salary slip, sorry, please come to page para 10 of the impugned order.
Yes, ma'am.
Now, salary slip shows, this is a finding, this is not challenged by you.
No.
You earn 58,
Yes.
minus son expenditure of about 56,000.
Correct.
We'll look into that.
Yeah.
Before that, the income of respondent is 1,62,000. Joint income of the parties per mensem is such and such from jointly owned flat, which he denies, but we are not much on that because if you say it's a joint income, then your incomes cancel out each
But
other.
joint income, perhaps the learned trial court wanted this 2,20,000 wanted to add up 162 and 58, and then came to this joint income.
No, from the flat.
No, my lord, joint income of the parties
Okay.
is rupees 2,20,000 plus 18,000 rent.
Rent from jointly owned flat. So if
So
the
that brings up to 230.
18,000 rent from jointly owned flat, I am discounting because your income's jointly owned, so cancel out each other. We are,
But I am not receiving that thing. That is not my instruction that I have been receiving that.
there's no. Did you give you any proof that he's earning or is a rented accommodation?
My lord,
He's saying
apart
it's
from-
vacant.
Apart from the instruction that I have got, if my lord says I can put in a very short affidavit.
No, in revision we won't permit you. Whatever was before the court will.
But my lord, what is my instruction is that my learned friend's client, that is the husband, has a rental income of 18,000.
Instruction
the-
won't do, Mr. Guho.
Then
If
my
it
lord,
was
can-
not before the court below, we cannot know. We don't find any evidence being relied on by the trial court regarding the rental income. So we have to proceed on 1,62,000 and 58. I am proceeding on that premise. But then,
Yes.
if you are earning 58 lakh, it's not that if you whatever your husband earns, it has to be equalized with you. The test is whether you have got sufficient income to maintain yourself.
to an extent, 60 is
58,000
concerned, 60 is mine. But my lord, kindly
For
appreciate
the
this.
son, yes, definitely.
There has been no payment till date. That is what
No,
I
for the
wanted.
son, we'll consider.
Yes,
Mr. Bose, this is not a COVID law sort of thing going on. Please take your seat.
my lord, what
Yes,
I
sir.
can understand, if my lord kindly, because I'll try and satisfy on my lord's queries, but what instruction that I have got is in the year 2023, only once the husband has paid 79,400.
Oh, I'm telling you, we are not bothered with that much now because you are entitled to execution and you have levied execution. Quite rightly, you can get an order there. Whatever you can get in attachment even or send him to jail.
Yes, sir.
We'll do that. But about this 50,000, this is without
But
any basis. There is no material
50,000
basis.
is only for the son, my lord, and me. That is what it has
No
come to.
quantification. It has been stated. I do hold that an amount of 50,000 per month as maintenance. On what basis? 25,000 litigation cost.
Perhaps the trial court tried to.
We cannot look into the mind of the trial court, Mr. Go.
But my lord, when the son's expenses is 56,000,
Shows that from your affidavit of asset.
my lord, that is the recording in the order itself.
We won't go by that. That is
Then, my lord,
precisely what has been
kindly
challenged.
grant me one opportunity, keeps it next Friday.
No,
I'll come back.
I want to see everything has
From
been
records only. From records only. If
only from the records right now. Why next week? St. James School, you have annexed the school fees and all.
Definitely, my lord.
He's 14 years old,
12 years.
12 years. So about class 6, 7 maybe.
Yes. So my lord, that page,
This is of class 2.
page 132, my learned friend,
Yes.
senior friends, has only enclosed his class 1 and 2.
Yes, but he has enclosed your enclosures.
These are all old. 2019.
What did you produce?
My lord, that I have to check, my lord. Currently, immediately, I don't have that thing
But
readily
nothing is
available.
disclosed in the impugned order. The judge, learned judge all on a sudden says yes.
No, my lord, definitely after considering the affidavits. Has
Yes, but
only-
what is the ratio? What is the ratio? We cannot look into the mind of a judge.
Definitely, my
The
lord.
reasons have to be reflected in the order. The order says he earns 1,62,000, you earn 58,501, joint income 18,000, total earnings such and such in the light, keeping in view the liabilities and heads of expenditure. Now, I am not even looking into his expenditure for his uncle, aunt, all those things. We are not looking into that. Definitely not. Because even if he had that uncle and aunt, he had to maintain you and his son.
Absolutely.
But 50,000, there is no basis to this.
My lord, 50,000.
For the son, I can appreciate some amount is necessary, yes. You also have to share some amount because you are also earning.
Kindly see, my income as on date is 60,000. Now I have been maintaining my son all along. Unless August 2024, my learned.
When did you file the application for alimony? It has been granted from the date of alimony.
2019, this application for maintenance.
No,
26 November.
It has been granted from the date of the alimony, the
Yes,
application.
yes.
So I'll maintain that. It has to be from the date of the application.
Correct. So 26 November 2019, I have.
Whenever you filed the application for alimony, but at best for the son we can grant 25,000, half of this. Why 50,000?
Well, let me bring on record the affidavit that has been filed, if that is not, because I don't find it in the revisional application.
Yeah, you haven't annexed the affidavit filed by the wife.
My lord, I have annexed. If you lordship,
Which page?
if you lordship once takes the trouble to look at page 139, I am continuing paying 25,000.
We are not interested. I'm asking a specific question. Show me the affidavit of asset filed by the wife in the court below. You must have annexed that. You cannot suppress that. My lord, so there is a chart that has been, perhaps my lord will find. You have given a chart to me.
My lord, my client only.
These charts were before the court below.
Yes, my lord, because this contains the 56,530.
No. We can't rely on chart. We have.
Backup is there.
I want to look at your affidavit in opposition, the affidavit of asset.
However, my lord, the
You are not
backup-
prepared on that. You have got a copy of the revisional application. You knew the application is appearing in the list. You should have taken it from your client. The court would, that is the first thing the court would ask for. Your affidavit of asset in the court will.
Just give me.
From the order, I don't find any premise, any reasoning. Only your cases have been reflected, and yes, there is a finding regarding your respective incomes. But this I do hold has no
Yes.
premise, no reasoning. Why 50,000? You are earning 58,000 yourself.
But my lord, my entire money is going to maintain my son. Then how will I maintain myself?
50,000 you cannot spend for a
Because my-
6-year-old son, 12-year-old son. You cannot spend
My lord, that is
50,000
the
per
breakup
month.
is given before the
That's
court
an
below.
inflated breakup.
That is the breakup that has been given.
Show me the affidavit of asset.
My lord, this is a.
Neither of you are ready with your affidavit of asset.
My lord, may I
I
just.
suppose you should have annexed.
My lord, may I just hand up this affidavit?
This is an affidavit of asset in the filed in the code
No,
below.
my lord, this is affidavit in chief, not the affidavit of assets.
That won't do.
I understand.
Rajanish versus Neha is for that purpose only. Such as
No, my lord, this is not the affidavit in.
Mr. Go, I'll set aside this order. In the
My lord,
meantime,
may I just.
no, I'll remand it. And I'll direct the learned trial judge to decide within on the materials on record to assess on the basis of the affidavits of assets of the parties and reflect that has to be reflected in the order. And regarding this 50,000, in the meantime, till disposal of that, I'll fix a time limit. Till disposal, only 25,000 for your son for the time being ad hoc.
May I beseech one thing, my lord? My lord, what I understand, my lord, maybe currently I'm not having the affidavit of asset. That is my lacuna. But my lord, give me one opportunity till next Friday. If the affidavit of asset is there, let me bring it before the
Very,
court.
very.
Because since the court has come to the exact finding and I am having the breakup on my hand. So my lord, this exact finding of 56,536 that is there with me. So
Bring
must
us-
have
we
been,
copy
it
of
has
the
been
affidavit of
filed.
asset. Yes.
Allow me to bring it, my lord.
The present revisional application has been preferred against an order whereby monthly alimony to the tune of rupees 50,000 per month has been directed to be paid by the petitioner husband to the opposite party wife along with rupees 25,000 as one-time litigation cost. Full stop. Learned counsel for the petitioner argues that the learned trial judge failed to take into consideration the huge expenses of the husband stroke petitioner. Full stop. Next para. However, learned counsel for the opposite party controverts the same and submits that the opposite party wife is having to incur expenses for the minor son of the parties who is living with the wife. Full stop. Moreover, it is submitted that the husband has not been paying alimony since long. Full stop. Next para. From the annexures to the revisional application, I do not find that the affidavit of assets filed by the wife in the code below has been produced. Full stop. Learned counsel for the opposite party wife is also not prepared today with the affidavit of assets filed by the wife in the code below. Full stop. Since prima facie, I find no reasoning behind the fixation of rupees 50,000 per month as the quantum of alimony, an opportunity is granted to the learned advocate for the opposite party wife to produce her affidavit of assets filed in the code below in order for this court to properly and completely adjudicate the present revision. full stop. Accordingly, let the matter stand adjourned till March 28, 2025.
Maybe the week there,
No, 1 week.
because I'll apply for the certified copy and I'll come, my lord. In that, even in case if I otherwise I'm
Adjourned till April 4, 2025, when the matter shall be listed under the same heading, full stop. On the returnable date, comma, the opposite party shall furnish a copy of the affidavit of asset filed by the opposite party wife in the court below with an advance copy to the learned advocate for the petitioner. This much. Not now, 2 weeks only. Execution case is levied.
Yes, it's in July. The next date is in 4th of July 2020.
Since I am informed by the learned advocate for the opposite party that the next date of the execution case levied by the opposite party to implement the impugned order is in July 2025, comma, that is much after the returnable date of the revisional application, comma, no orders are being passed in respect of the execution case at the present juncture.